All right, hi everyone. Hi, welcome back. Welcome back. So I've graded your exams, but not ready quite yet, and it's not my fault. A number of you did not use the correct exam number in your books. Some of you wrote your birthday. Some of you made up numbers. I don't know what you did. We've actually tracked down everyone, so I know who all of you are. So your grades will be ready tomorrow. But if you use ExamSoft, you couldn't screw up because put the number there for you. But for people who used a blue book, a lot of you use numbers. Now, some of you, you told me you were going to be using numbers, and I got that. But for some of you who didn't warn me, the numbers used were not correct. But we tracked them down. Literally, a couple people, the registrar figured out because it was your birthday. And that's how we narrowed it down. So we got you, don't worry. Everyone in the class, we got. In my property class this morning, there were a couple people who we could not figure out what the numbers were at all because they weren't the birthday, they just made up numbers altogether. So here's what's gonna happen. I need to do the curve tonight because I only got who you are today. You can pick up your papers tomorrow. I don't know what time when Shalonda finishes printing them out and getting everything collated, but it'll probably be ready by tomorrow around, I don't want to give it time, some point tomorrow. So just stay in the building. She'll be here tomorrow. Because all of you are so antsy about reviewing it, what I'm going to do is tomorrow at 5, I'm going to send around an email to both my sections, property and ConLaw, saying, here are all the time slots between now and the end of the semester when you come meet with me. I'll send it at 5. That way there's no advantage. Everyone can go check it at the same time. Whatever time slot you pick, that will be your time slot. Make sure you come in that time slot because if you miss it, you have to get next in line. I'll have my normal office hours. If you want to come talk about something else, stop by noon, whatever you want. But if you want to talk about your exam, I want you to pick this slot. The reason why is I have 170-something students in both sections, and there's only so many hours in a day. And I personally think it's discourteous to let people just sit in the hallway and wait an hour until their time is up. So I will stick fastidiously to the schedule, pick a time, I won't remind you. I will caveat this. So if you got a C or lower, you have to come meet with me. It's not optional. I am not going to chase you down if you don't make an appointment with me. I can't drag you, but it's obligation if you got C or lower. And this is not for my benefit. This is for your benefit. I want to make sure, if it's possible, we can correct what was off, right your path, and get you higher up. Although, as I think I mentioned last week, the grades in the midterm are a pretty good predictor for the grade in the final. Most people stay about where they are. Some people go up a little bit, some people go down a little bit, but there's very little jumps. So for those of you who took the midterm seriously, you're in good shape. For those of you who didn't, you need to work. There were no failures, so no one totally missed the mark. That I have failed people in the midterm before, so you're not in that shape, but it's happened. No one wrote 1,000 characters, which I was actually pleasantly surprised because in the past 2 semesters, someone wrote the equivalent of 4 text messages for their midterm. A couple people went over the word limit, but like maybe about a sentence or 2, so it's nothing actually egregious. Didn't indeed change the outcome. If I have some time at the end of class today, I'll do a little review, but today's a fairly jam-packed class, so I have to wait till next session. Yes, sir.
So, as I take it, all the exams, not just the handwritten ones, will be printed and available.
Yeah, I mean, if you blue booked it, you'll pick up your blue book. The challenge was figuring out whose blue book was who, and I think I've now figured out. If for whatever reason you get the wrong blue book back, tell me immediately. But I think I've worked with the registrar; they're very helpful there. They check your birthdays, and I think 3 or 4 people did their birthdays, so it's actually fairly easy to check. And just so if one of you, not your fault at all, the ExamSoft never uploaded. I hadn't seen this before, so if for whatever reason you're ever taking any exam and you don't get like a confirmation of upload or whatever, go to the registrar because they can extract it from your computer. Like I'd never seen this before happen, but apparently it happened. So if it ever happened, your final exam, don't freak out. Because in years past, believe it or not, I've had people not show up for the final exam or not show up for the midterm. For the exam, you get a 0. So always be sure that your software uploads the paper. If through no fault of your own, and again, it's totally computer error. but you need to do this. And one of the notes, for those of you who decide to handwrite for the final, I strongly suggest you would consider none of your handwritings are as good as you think they are. They're not. They're not. They're not. No one has a good handwriting under pressure in an exam. You don't. You simply don't. You can't. You're figuring out other things. The other issue is it makes it very hard to edit. And with all the cross-outs and the lines, it makes it harder for me to read. If you don't believe me, think about the bar exam. I want you to, if you're bored, go take a look at the bar exam. Too many people take it by hand or by computer. It's not even close. You're handicapping yourself. And you say, well, I do better taking on paper. Okay, train yourself. You have 3 years of law school to get better at typing. It's again, it's annoying for me because it's hard to read sometimes, but I figure it out. The chicken scratch, I'll get it. But you're handicapping your own abilities. And if you don't have a computer, I understand, find a way to borrow one or obtain one. One semester I screwed up. I told a student that I can have the school will lend you one because we have laptops, and they said no, we can't lend them. So I got in trouble. But find a way to get a computer for finals week if you can. But again, if you don't want to, that's your call. I can't make it. Questions? It's for your advantage. Okay, so for today, we will continue our discussion of the Equal Protection Clause. And if you can even remember back before spring break, feels like forever ago, right? But if you remember back before spring break, we were talking about race and how the court has applied the Equal Protection Clause to various racial classifications. And the court, more or less, has centered on this notion of strict scrutiny for race. My goal for you for today in particular is not to simply memorize, here's the test for strict scrutiny. Here's the test for intermediate scrutiny. Here's the test for rational basis scrutiny. And I can recite this for you, right? Anyone with Erwin Chemerinsky's Horn book can recite for you what the black letter law is of scrutiny. I don't, that's easy. No points for that in the exam, right? That won't get you anything, right? I want you to understand how scrutiny actually operates and what is going on underneath the hood, so to speak. Because that is far more important than memorizing these tests, because these tests change every 5 cases, right? So let's start again with this notion of strict scrutiny. Strict scrutiny began, or at least in its present form, with the Korematsu case. And the question in that case was whether a racial classification can be justified for Japanese Americans from the coast. And remember, Korematsu was only about exclusion. It was not about detention or curfew. Those are the other cases, Endo and Hirabayashi. Korematsu was only about exclusion. And as developed through a number of cases, the court settled on a framing, and I'll give it to you. Okay, so the classification on the basis of race must be narrowly tailored to serve a compelling government interest. Okay. And not that we mention it, but it's not just race, it's race, nationality, alienage, and religion. Not that it matters, but those are the other things which we don't have time for cases on. So if the government decides to classify people on one of those bases, and it's almost always race, religion comes up every now and then, but it's usually race, the classification must be narrowly tailored to serve compelling governmental interest. Okay? Where did I finish off last time? Does anyone remember? Shh, are you next? Oh, wow. Good memory, Troy. Okay, thank you, sir. Troy, let's go through this. Let's go through this really carefully, right? What's a compelling governmental interest?
I think that this is something that helps them achieve their objective.
Who's they?
Oh, the state or whatever.
Well, what does compelling mean? What does obviously objective is a synonym for interest, right? They're trying to achieve some sort of end goal. What does it mean for an interest to be compelling, Troy?
It has to be close closely related to
What do you mean close? Well, no, just compelling. I'm not talking about tailoring. What does compelling mean?
rational basis.
Oh, we're definitely not rational basis line. Am I going this way or that way? Ah, your next Phil?
Would it be like an important governmental interest?
Important. What do you mean important? How do we know? How do we know it's important?
It's something that the government really wants to get done. This is the way that they think that it needs.
So if the U.S. government comes to the court and says this interest is compelling, is that the end of the story?
No, they have the burden of proof.
Who has the burden of proof?
The government.
Okay, and then you're dodging my question. I'll hit it to you again. Who ultimately decides if the interest is compelling or not?
Would be the court.
The court. The court. So make no mistake, right? When the government puts forward the strict scrutiny test, and they say compelling government interest, this is not what the government says. This is what the court says. So Javier, let me ask you this next question. How do 9 justices, or maybe 5 justices, as it were, decide what is compelling?
I think they give the government the benefit of the doubt, basically taking them at their word, saying that what they're doing should be allowed, or at least give some discretion as to how they use whatever they
So you think the meaning of compelling is you give the government the benefit of the doubt?
Yes.
Jared, what do you think? What does compelling mean?
One or more things without each other.
Well, Jared, let me ask you the question a different way. Think of the cases we've done so far where the court have upheld classifications on the basis of race. Which cases have we done so far where they've upheld those classifications? Korematsu is one of them. Good. What's another one? I think all the way back before Christmas or spring break. Exactly. Gruder, yeah, that was the other one. Okay, what was a compelling interest in Korematsu, and what was a compelling interest in Gruder? So you remember, pop quiz memory, right? Give me one. I'll go to a Randy for the next one. Right, you're on deck. So, what was a compelling interest in Korematsu? Start there. Oh, take it. Yeah, she took the easier one, right? Yeah. What? So that's fine. All right, Jared, you're done. You're done. Fine. Randy, go ahead. Say it again, please. Okay, so the compelling interest in Korematsu is national security. What was compelling interest for Gruder? Congrats. Either one.
Okay, no, I'm just kidding.
Well, all right, one time. Do you have it or no? Yeah, Laura. Actually, Javier, take it back. Whoa. Be precise. What was a compelling interest, though? Be precise in describing it. Not quite. Yeah, right. So the educational benefits that flow from diversity, right? That was Justice O'Connor's. Critical mass is right, but specifically, it was the compelling. It was the interests that flow from diversity in the classroom. Now, who's to say if that's compelling or not, right? I'm sure if I took a poll in this class, maybe some people say this, maybe some people say that. I don't know. But the court is deciding what compelling is, right? The court is deciding based on their own sense of policy, right? If any of you are watching the Supreme Court confirmation hearings this morning, Judge Gorsuch gave his version of the I'm an umpire throwing balls and strikes. He said, I'm not an algorithm. I'm not an algorithm, right? Judges are human. All men are mortal. And when they're deciding what's compelling, they draw on whatever principles they have. So this is not some sort of mechanical approach. Even deciding what's compelling is based on something the judge is drawing from inside. Dan.
So would it be fair that the analysis could start with looking at state powers or state police powers of ensuring health and safety and well-being, and sort of work a formula down from there? Or?
Well, you're doing some work there. What are you doing that work based on? Look, I'm not being critical. Please don't get me wrong, right? Judging is a human enterprise, and this is not some sort of partisanship. I hope if you watch the hearings, you don't get disillusioned by the various statements by senators that, oh, you're a politician in robe, right? You know, you'll hear that, but there is a human element of judging, and you can't deny it. But I'm explaining to you how exactly it works, and they put forward this test: compelling interest. Who's deciding what's compelling? Right, the judges. right? All right, Laura, let's move on, right? Then the other part of the scrutiny test asks if the classification is narrowly tailored to serve that interest. What does it mean for a classification to be narrowly tailored, Laura?
If it relates back to why they're trying to do whatever it is that they're doing.
What do you mean relates back? Give me a little bit more than that, please.
Can I use an example from a case?
Please, please. By the way, for exams, use cases, my God. So many people did not cite a single case in their exam. Why? Why? All we do is talk about cases. That's all we do. So talk about cases, mention them, discuss them, bring the facts in. The weakest exams you'll see are those that just give policy, didn't discuss any cases. You want to get an A, talk about cases. So Laura, please, give me a case. I'd love a case.
Okay, so like in the United States and Virginia with the school.
Good example, yeah.
They were trying to keep women out of the military school.
Right.
And so the narrowly tailored would be if the reasoning for them keeping women out relates to their compelling interest of why they wanted them out in the first place.
I think you're going to be right. Say it a different way. What exactly is a court assessing between the link between keeping women out and running this military academy? What exactly is the court doing? What's the mental process? You're exactly on the right track.
If they could see that it's reasonable or not to them.
Well, not reasonable. What does this say? What's
It's compelling.
no. Wrong finger points.
Narrow.
What does that mean, narrowly tailored? Let's focus on that meaning for a second. Specific. Okay. Mateo, you want to add anything to that? I'm not asking you. You should add something to it. It's not asking to volunteer.
Both have the same means at the end, so
Oh.
the government goes by achieving that, and or in this case, compelling information to be more specific and narrowly tailored. They can't be like burdensome.
Okay. Jared, what do you think?
Could it be more so not that, like in Virginia, that they're not doing it solely for the fact of being sexist and keeping women out, but rather doing it for the strong history tradition that.
So you're saying that there maybe is a good reason why they're doing this, not a BS reason.
Correct.
Okay. Everyone heard what you just said. I think between the three of them, they're on the right track. By the way, Laura, I appreciate, but the Virginia case was not strict scrutiny, though.
No, it wasn't. It was
But it sure as hell was. Cameron, you want to add something? Yeah, whoa.
Say that's not, narrowly tailored because the distractions would take, fires from, I guess, Washington and Wood building, you would go about it a different way. That wasn't a reason.
Exactly. That's actually a perfect case to think of. Yickwo v. Hopkins, right? I'll get you a second. So let's use Yickwo as an example. I think it's an even better example in Virginia. They said if you want to register a laundry in a wood shop, right, you need to get this license. Okay? The license had nothing to do with safety. It didn't require you to have, fire extinguishers, maybe build a wall made of stone around your furnace and your laundry system, right? And the court said, look, we know why you're doing this, right? You're not having this licensing regime, right, to promote safety. You're using this licensing regime to keep Chinese people outside the industry. BS, if I may use such a crass term, but bullshit, right? This is bullshit. This is not the real reason why you're doing this. The reason you're giving us is fake. If I may, the word pretext, if you know what that word means, like pretext, like you're giving me a reason, but that's not the real reason. So the enterprise of tailoring is to see how close your means and your end are. If your end is safety in buildings, they don't burn down, what are the means you're using to get there? I don't know. Keeping a fire extinguisher nearby, inspections to make sure that there's, ventilation, right? Inspections to make sure that people don't have, old crappy equipment, right? I think everyone in this room would agree that if you have a law saying you need to have an inspection once a month to make sure that your equipment's safe, that actually relates to fire safety, and there's a close connection there. But if it's you apply for an arbitrary license that's handed out whatever without any indication if you're safe or not, that's not related. But the crux of strict scrutiny, and Yuko predated strict scrutiny by maybe 50 years, but it was doing strict scrutiny. The crux of strict scrutiny is it doesn't just have to be related. It uses this phrase, narrowly tailored, meaning this has to be the least restrictive means to achieve your goal, right? The least restrictive means to get there. So let's use Korematsu as an example. Go back to Korematsu. The court basically said that this was the only way, this exclusionary policy was the only way to protect the coast from attack. Remember we asked, well, why can't they use loyalty oaths? Remember we discussed this, right? Why can't they use a loyalty oath? The government said, look, we don't have time to do loyalty oaths, right? We have to get this done quick, and maybe people can lie to us. And the court said, we're not going to second guess that. If the goal is to protect the coast, the court said, the most narrowly tailored way to achieve that compelling interest was by a blanket exclusionary policy. If I polled this class, I don't have the means to do this, but I'm sure if I polled this class and I said, was there a more narrowly tailored way to protect the coast and to round up, a couple 100,000 Japanese people on buses and put them in the desert? I think every hand would go up, if not most hand would go up, right? Safe to assume? So again, the enterprise deciding what is narrowly tailored is a judgment call. I asked 80 people in this room this question, I'll probably get 80 different answers. Right? How necessary was the Chinese exclusion? I'm sorry, wrong case. The Japanese exclusionary policy. There was a Chinese exclusionary case also. But how necessary was the Japanese exclusionary policy to achieve that goal of protecting the coast? Was it 100% necessary? Was it maybe 75% necessary? How close must that fit be to work? Right? How close does that fit have to be? So Korematsu is often criticized for being a, if I may keep the cursing going, a bastardized version of strict scrutiny, right? Finding this narrow tailoring, but it seemed pretty damn broad to me. I'm cursing today, I'm sorry. I was, I gave a lecture yesterday at law school in Orlando on the First Amendment. It was a Christian school, and I was saying fuck the draft and stuff, and they got all mad at me. No, we'll do the fuck the draft case. We will. There's a case about that, Coney, California. Stay tuned, my friends. Lots of cursing in this class. Once a student, she brought her daughter to class, maybe 8 or 9 years old, and I was teaching that case. I was like, "Can I curse?" She's like, "Yeah, go for it." So anyway, happened. Anyway, going back to this, Korematsu is often criticized for applying a very lenient form of strict scrutiny, if I may. Right? Because yeah, there's probably something more narrowly tailored than a massive exclusionary policy. Okay, by the same, Chris, I'll get you in a second. Almost done. It's a big wind up to gender. I'll get there, I promise. So by the same token, the court's decision in the affirmative action cases, right, Grutter and others, has a similar criticism of how compelling are the interests from diversity. This is Justice Scalia, Justice Thomas, and others. Does the benefits from diversity rank at the top of the pecking order to justify being compelling? Thomas and Scalia said no. O'Connor majority said yes. So the enterprise of strict scrutiny, and I don't want to say this lightly, but it's an important point, is based on value judgments about what it means to be compelling. That's not written in stone. And what does it mean to be narrowly tailored? Right? Those are not mathematical decisions. In fact, Justice Stevens' dissent in Craig v. Boren, where he says there's only one equal protection clause, I think reflects that. And Justice Rehnquist's opinion in Craig saying, look, we're not statisticians here, right? We can't run regression and make that decide the fate of constitutional law. So even strict scrutiny, which had been in existence, Korematsu and other cases, doesn't give a rigid approach. There's still a significant value component. So for your purposes, when you're on the exam, right? If you're doing a strict scrutiny analysis, I want you to tell me, why is this a compelling interest? Don't just label it compelling. That's lazy. Don't be like the Supreme Court. Tell me why something is compelling. And don't just say, oh yeah, this is narrowly tailored for this and that. Explain, why is this the least restrictive means to get there? Why is this the only way of getting there? Other means are simply impracticable, right? You can't give a loyalty oath. You can't do this. You can't do that. You can't use a top 10% plan, right? Give me something precise about why that is narrowly tailored. And if you give that to me, you will be doing a hell of a lot better than the Supreme Court, because they are very opaque on this. When they get down to it, they don't want to tell you why something's compelling, because they realize people say this, you know, the man behind the curtain, right? That's not an answer. Okay, Chris, you've been patiently waiting, and then Jens, you're on deck.
Well, you did kind of answer.
I love when I do that.
But that gave me a follow-up question.
Good,
So,
go for it.
So, for instance, like when you're saying give you an example of why something is compelling or narrowly tailored, would you want us to tailor it to the time period as well, since the court has really been fluctuating?
Yeah, and I mean, it's not just the time period, but if you're in the time of war and you're under an active invasion, maybe loyalty oaths simply are not practicable.
So context and
context matters, right? Context absolutely matters.
And the court has just been so back and forth on how widely they read.
Yeah, and that's why I don't want you to take this as some sort of gospel given down from God at Sinai, right? There's a very human component of this strict scrutiny. And I didn't even get to the preliminary question. My third question, Jens, I'll get to in a second, is this little race, nationality, age, religion. This is my transition, by the way, to gender, but how do we know which classifications to be given this strict scrutiny? And how do we know which classifications to be given what's now called intermediate? And how do we know which classification should be given, well, what we call rational basis? These are not compelled by the Constitution. There's nothing in the Constitution that says race has to be looked at more closely than gender. It says that nowhere. It says that nowhere. This is Justice Stevens' point. We have one equal protection clause. Just as the court ranks various government interests, well, this is important, but that's compelling. And the court ranks tailoring. Well, this is substantially related, but this is narrowly related. So too, the court ranks classifications. And they've said race, alienage, nationality, religion, those classifications are no good, and they must be scrutinized strictly. But over the course of the 70s, said, well, gender's, somewhere in the middle, perhaps a gender-based classification is accessible here, but not acceptable here. And then everything else falls to the rational basis ash heap, right? And there's nothing wrong with that necessarily. But how is a judge to decide which bracket, if I may use a March Madness term, right? How to seed his scrutiny, right? Where to put your various classifications. That, again, is inherently human judgment. I think Justice White's opinion in the Cleburne case comes closest to explaining why they're doing what they're doing. But as Justice Marshall's dissent points out, it's not very persuasive. Jen's patiently waiting. Did I answer it? Good. Anyone else? Anyone else? All right. So that's how I wanted to segue to this notion of, and I built it up deliberately. First, how do you define how big the interest is? Second, how do you define the tailoring? And third, how do you decide which classifications get different treatment? Which brings us to gender, right? You've actually had a gender discrimination case very early on. You remember what it is?
Yeah, that was the lawyer.
Yeah, Bradwell v. Illinois. Remember that was the case decided right after Slaughterhouse about whether the woman who wanted to get a law license from Illinois could claim that was a privilege or immunity of citizenship. And in a very harsh opinion, which I think a lot of you reacted to at the time, Justice Miller or Justice Bradley? Bradley, thank you. Justice Bradley went on this entire rant about how women's home is in the domestic, right? And that's where she belongs. And it would be counter to our entire legal order to permit this woman to have any privileges or immunities. Even though the day before he had ruled for Slaughterhouse that male bakers did have this right to earn a living. Again, I forgot to put it up here, but the 14th Amendment, right? The 14th Amendment, do I have a constitution? Oh my God, I feel naked. Oh, God, it happens. When I pick up my suits from the, don't, please, I back up, please. Please, I always carry extra. These come in handy. I can't tell you. I always have backup. I can't tell you how many times I've given these away. And this has happened twice, where I was randomly like somewhere and I met some guy who had just taken a citizenship oath. I'm like, here you go. Like once I was in an Uber and the guy's like, yeah, I'm studying for my citizenship. And I was like, here, study with this, right? And another time I was at an airport. This guy's like, yeah, I'm just taking my exams. Like, here, take one of these. So always carry extra. They come in handy, such as when you're come back from the dry cleaners, you don't have your suit. So if you look at the 14th Amendment, right? I forgot to put it up here. I apologize. It says, all persons born or naturalized, ... No state shall deprive any person within its jurisdiction the equal protection of the laws. Notice it says any person. It doesn't say any man. It says any person. There are places in the Constitution that say he, it uses the male pronoun. This is not one of them. It says any person. And the suffragists in the 1800s were very adamant to look at this Constitution and say, look, the Constitution says nothing about men or women. It says persons. Persons have privileges. Actually, citizens have privileges or immunity. So this led Myra Bradwell, the attorney from Illinois, to say, hey, look, I have this right to earn a living. Right? I have this right to earn a vocation. The Supreme Court said, no, you don't. There was another case, which I don't assign anymore, called Minor versus Happersett, which involved a woman who tried to vote. And she said, look, it says right here, you can't deny any person the equal protection of the laws. Give me a ballot. Indeed, Susan B. Anthony persuaded a election officer to give her a ballot, saying, look, Constitution. She actually, she had a pocket Constitution also, right? I don't know if she actually had a pocket, but she showed him the amendment. And the court ruled against another woman saying, no. If you need the 15th Amendment to give the right to vote based on race, then you need another amendment to give the right to vote based on gender. And indeed, the 19th Amendment in 1920, I think the year was, provided women with the franchise. But that didn't go much further than that. The 19th Amendment only discussed the right to vote, which brings us to the gender cases. Throughout the 50s and 60s, the court began to expand on the application of strict scrutiny for race, beginning with Brown, and you did a lot of other cases, Loving and others. But gender was left largely on the side. And until the 1970s, there were many cases that actively put classifications on the basis of gender. Leading the charge against these cases was none other than Justice Ginsburg. Back then, she was just Ruth Bader Ginsburg. And she worked for the American Civil Liberties Union in the Women's Law Project. And her mission was was actually twofold. But part of her mission was to litigate cases to get the court, and indeed the Supreme Court, to look more closely at gender-based classifications. And Ginsburg's strategy, and this is legendary, I'm not telling you anything secret, her strategy was very smart. She picked cases where men were being discriminated against. If you look at the cases for today, they have something in common, right? In Frontiero, the husband was getting a lower allowance, right? In Craig v. Boren, the men weren't allowed to buy the beer at a young enough age, right? These were cases where indeed men were being treated worse. And the thinking was that if we start with these cases, that the judges would be more willing to grant relief to equalizing things for men, rather than starting off with things that hurt women, right? That was the mentality, that was the belief. These cases are very fragmented. You're not assigned the first one, called Reed v. Reed, but that was the first case in this sort of trilogy. But there was Reed v. Reed, there was Frontiero v. Richardson, and then there was a Craig v. Boren. And these cases decided in the early to mid-1970s began the Supreme Court's process of elevating gender classifications up from rational basis scrutiny to something more stringent. Now, before I go to these cases, I want to reiterate a point about strict scrutiny. The strict scrutiny test was often viewed as fatal. It's in your book by Gerald Gunther. Strict in theory, fatal in fact. And the notion that compelling, that means really damn important, how we define it. And narrowly tailored, that means you got to choose the most precise means necessary, and if you don't, it's unconstitutional. Throughout the 1960s, once you had a racial classification, it was toast. It was toast. It wasn't getting upheld. Sorry. Right? Once the court decided that strict scrutiny would apply, spare yourself, you're gonna lose, right? The government had an insurmountable burden. The government had to disprove every possible reason, right? Why the law was the way it was, right? It could never happen. The struggle, though, was would the courts afford the same level of scrutiny to gender-based classifications? So before we go to the first case, I want to look at a word that you may know what it means. Nancy, I think you're next. You're next. What does the word immutable? Immutable mean? Anyone know? Yeah, you can't change. Yeah. Immutable means you can't change something. And throughout the, I'll come back to you, Nancy, in a second. And throughout the, no, you're not done. Throughout the, throughout this period, the notion that certain characteristics of people are immutable. Race, for example. You're born a race. You can't change that. I mean, you could, I suppose, surgery and other things, but generally speaking, you can't change your race. Nationality. You were born in a place. You can't change that about yourself. I'm about to say something, people raise their hand, but I'll say it anyway. Gender, right, was viewed as something that could not be changed. Today, that perhaps is not as orthodox as it once was, perhaps, but gender was viewed as something you were born with, right? You're born with genitalia. I mean, you can change, I suppose, but your chromosomes, they said, right? Okay. Agree or not, unimportant for now. We're talking the 70s, okay? Every year I teach this class, it changes. No pun intended. No, not deliberate. So the view was people are born with certain characteristics, right? You're born with them. Through no fault of your own. That's who you're born with. So Nancy, are there reasons why the state may treat people differently, not based on what they do, but on these sorts of immutable characteristics? Oh, good. Okay, tell me more about stereotypes. Not where I was going, but it's a good direction.
In one case, this is the last one, with the military Virginia school institution, they were saying that women could go into school because they weren't strong enough to do what men could do.
Right, okay. So the thinking is, right, and I like the way they use the word stereotypes, it's a good word. The thinking was that when you're classifying people based on an immutable characteristic, it's not based on anything specific to that one person, but it's based on stereotype or a general norm, right? So, did I do this already? Patrick, so let's just go through the case. We'll do the case later, but let's do the facts of each case separately, right? In Frontiero, the first case, why do you think the government made it harder for male spouses to collect benefits than for female spouses to collect benefits? What do you think that stereotype, to use Nancy's word, was premised on?
Well, I think what the government said, their reason was for like administrative convenience.
Well, what do you mean administrative convenience?
I guess it was just easier to classify, like, okay, so here's a man with a independent woman, and they're in their category, and then female with a
Okay.
male.
Now, I'll go back to Nancy's question. What do you think the real reason why is they had that?
It was just a stereotypical, like male is, the breadwinner, traditionally.
Yeah.
I guess back then.
Yeah. Right. You raised your hand or you're stretching? I'm sorry, I didn't hear what you said. Oh, good point. Good point. I mean, and actually, this was 72, so women as officers was a fairly novel thing. I don't know the year to check on that, but it was pretty recent. But administrative conveniences, maybe veterans. But I think the rationale here was that it was a stereotype that if there was a man, it was almost presumed that the woman would be a homemaker, right? And if it was a female, it was almost presumed the husband would be working also. So the law was based on a presumption, right, one way or the other, that women were less likely to be the breadwinners, and therefore, if a husband was claiming these benefits, he's got to prove it. That way, they don't bilk the government of money, right? Everyone see that. I mean, it's not that hard to grasp. Jacob, let's do the second case in Craig v. Boren, right? Why do you think the state allowed girls to drink beer at 18 and boys to drink beer at 21?
I guess going with the stereotype, I think that they think women are more responsible.
Yeah.
Or,
Yeah, exactly. And what about boys? Don't speak from experience, right?
I think there's a very firm or sturdy stereotype that young boys probably don't know what they're doing.
Yeah, I mean, I suppose you could look at actuarial rates, like girl for insurance, a little bit less than a teenage boy. But indeed, I'll get you second, Jen. So the statute was premised on the fact that girls are more responsible, and boys are less responsible. Need to be a little bit more mature before they buy beer. Jen?
Wasn't that because didn't they provide the evidence that but they said that the evidence wasn't enough? So wasn't that?
I'm not getting the evidence. None of that evidence exists when this law was enacted. All this evidence came forward in litigation. I'm talking about people who wrote this law, however many years ago it was.
So how did today bars get away with letting in 18-year-old girls and not 18-year-old boys? They're saying, boys, you gotta be 21.
People challenge happy hour specials. You've seen these, right? Girls are free before 10 p.m. Right? Girls get a free drink ticket. This was a while ago. This was in New Jersey while I was still living back in New York. But some guy, a bar, because they wouldn't give him a happy hour discount. You're laughing. But it's premised on the stereotype that you need to get girls in the bar to attract guys. I mean, I've been to a bar. That's why they have those specials. And Nathan, your question's not insane. I mean, under the law, perhaps that could be done. But the law was enacted originally, I think, because of Jacob's rationale that there's a presumption that girls are a little bit more mature than boys, right? And Jorge, let me ask you this question next. Let's go to the VMI case, right? Why do you think initially, 150 years ago when the school was founded, they made it a boy-only school?
I think there's women who are allowed in the military.
Good. And then when women began to be admitted to the military decades and decades later, why did that policy not change?
I mean, they just wanted to continue with that idea, which.
What idea? What idea?
Well, basically that the leadership class was something that women wouldn't be able to understand.
Again, so stereotypes. I think it was 1 minute ago. So the general norm, right, is gender, which is immutable, maybe perhaps not today, but at the time was deemed immutable, was based on certain classifications of what men should do and what women should do. But there's still an uneasiness, right, where the court doesn't quite go all in and simply say that all sex-based classifications are subject to strict scrutiny. Sergio, my friend, right? Why do you sense this uneasiness in the court? Frontiero and VMI of just not going full hog and saying a sex-based classification. By the way, a funny story I'll give you in a second. Justice Ginsburg changed the phrasing from sex-based to gender-based. Why? It's a good story. You know the story?
Oh, I just know scientifically.
No, nothing to science, right? Because once she had her secretary typing a brief, and the secretary would laugh whenever she wrote sex discrimination. And she said, why are you laughing? Because it's a funny word, right? Sex, yucky, right? So she changed the gender so people wouldn't laugh when they're saying it. True story, true story. Sorry, so Sergio, back to your question. Let me repeat it so people can remember. I know you remember it. The question was, why has the court been uneasy in applying the strict scrutiny to gender-based classifications? It is a tricky question. I'm asking it to you. Why?
Honestly, I'm drawing a blank. I think in each case, in Frontiero, it was mostly because, for example, in Frontiero, the lower court said because it was more efficient, but reality, because of stereotypes. Eventually, it was because of stereotypes, and why did the courts? Honestly, I'm drawing a blank here.
Okay, Nathan, what do you think? Why do you think the court is hesitant about giving strict scrutiny to these gender-based classifications, whereas they have no difficulty doing it for a race-based classification?
It's because, well, I mean, gender is completely different from race in that you have gender, when you have females of different races and males of different races. So I'd be drawing a line because of that, like scientifically, and the fact that like gender isn't specific to a unique race. It's different in that each race has both genders in it.
What do you think, James?
I think like inherent ability. I know in the Virginia case, they talked about, I know in the dissent, they talked about how, I guess, if you put women and men together, it would change their ability to, they'll have to add and make more accommodations for women. And so, if you
Would the same
apply-
not be true of interracial schools?
No, I mean, I think you have to, it's for different circumstances, there's different, to put a black guy and a white guy in the same room and a man or woman in the same room, for different circumstances, it can lead to more issues. So I think that's why they're asking.
Jamie, what do you think?
I think to apply strict scrutiny, you have to have a compelling government interest, and in a lot of the things that we just discussed down this road, they give rationales for it, but they don't actually give reasons why it's compelling enough. And you want me to keep going?
Well, you didn't answer the question. Why do you think the court's hesitant to give strict scrutiny here for sex-based classifications?
I guess also they talk about how there's been a long line of it being separated, and that there is evidence that shows that sometimes it's better that they be separated. They're trying to change history instead of
Hey, Chris,
interpret it.
you want to take a stab? Don't worry, I'll get the front right. I forget about you guys. I'll get you there. You're next.
I
Okay.
think because like although there has been discrimination against women, and previously without the right to vote, it wasn't to the extent of the discrimination.
Oh, so in one of the opinions, I think it was Justice Brennan said that the experience of women in Jim Crow amounted to that of African Americans. Is that an accurate statement? What do you think?
No, because the discrimination wasn't to the extent not even nearly.
So you think there's a historical reason, perhaps, as well? What do you think?
That's what that was actually exactly what I was going to say. I think they talk about that, but it wasn't really like something that was to the extent of like, I think they're hesitant to apply it because women don't really have. I mean, in this time, like it wasn't like they were separated like they were African Americans were.
Ashley, I think that finish the entire row, go straight through, plow right through.
I'll start on same thing with history, that because obviously blacks have had a long line of just going against and being discriminated against. They probably want to apply a higher strict scrutiny to it to make sure that what the government's doing is necessary. So with gender, I guess I feel like
All right, I think I've got a minute time. We'll come back to. I appreciate the hands. I think if I could synthesize what the six of you have told me, there might be reasons for treating race different from gender based both on history in terms of the level of oppression that society has inflicted on various groups. I think Nathan and also Anthony also allude to the fact that there might be some actual reasons why men and women may be separated, but no good reason why black men and black women, black men and white men should be separated. Black, that's me. Right, so to use the example, which I used to give and now doesn't make nearly as much sense, is bathrooms, right? Like every year I teach, this example gets less salient, right? Houston voted on this not even a couple years ago. Does a state have a compelling interest to have a bathroom for black people and a bathroom for white people? I don't think so. I can't imagine what that compelling interest would be. There are not privacy concerns. The only possible concern would just be mere racism. The fact that you don't want to pee next to a black guy, right? That's basically the reason. Now, what about having a bathroom for men and bathroom for women? I don't know if any of you noticed in Justice Ginsburg's opinion, she had an entire discussion on bathrooms. Was that in your book case? Was that edited out? Oh, damn it. I read the original cases. I never remember what's actually in your case. Ginsburg had an entire section saying, well, they can have separate bathrooms because there's privacy and modesty concerns that you want a guy peeing next to a girl, right? 1996 was this case was. I don't know if that even fits in the court. She would probably renege on that statement today. But I think the court senses that in certain spheres, men and women may have certain roles. Combat in the military, for example, right? There's actually a case involving combat in the military where a woman actually, was it a guy? I can't remember which one it was, how the suit arose, but the question was, is a denial of women from combat in the military a violation of the Equal Protection Clause? Does a state have a compelling reason to not let women on the front line? They don't want them to get captured, subject to rape. This is actually a very divisive issue now. In fact, Congress is considering voting to, or if they haven't already, to allow women to the front lines. Now, the same question, would they allow a black guy and a white guy in the front lines? Well, what's the reason for that, right? Same everything, same physical standards. Even in a number of police departments, the military, the physical fitness standards for women are lower. They're lower. Fewer push-ups, fewer sit-ups, fewer pull-ups, longer times for runs. I mean, these are fairly objective measures. If you apply strict scrutiny to these tests, then they'd be unconstitutional. And you either have to, A, raise the standard for women, or B, lower the standard for men. You couldn't do both. You'd have to have a single standard for both people. And this comes up, there's actually a long-standing suit by the New York Fire Department where female employees are unable, female firefighters cannot meet the physical fitness tests. And they're being litigated about admitting more women to the force, and then the tests are becoming difficult for many to meet. So I think the sense in the court is there may be reasons why a state could legitimately treat differently men and women. Far more reasons than why they could treat differently black people and white people. Whether you agree with that is a fair question. But even now, with Justice Ginsburg's opinion in the Virginia case, no one's saying go for strict scrutiny. They've more or less settled in. Okay. But does it matter? I think it was Laura 20 minutes ago. Is what Justice Ginsburg did in the VMI case any different from strict scrutiny? Not really. Not really. She was pretty rigorous in her application. So whether or not you apply the label, right, whether or not you apply the label of intermediate or strict, the court can still, when it wants to, twist the screws a bit and give it a much more rigorous analysis. All right. All right, questions on that? There are lots of hands. I apologize for sweeping over you, but I want to get Jen's patiently waiting.
Could you say it's like the natural differences between men and women?
What's this word natural? What do you mean natural?
I mean, like as far as usually, and again, because nowadays you can do like take testosterone, take estrogen, whatever. But usually men are more stronger, faster, whatever, and that women are a little bit smaller, a little bit So that's what I mean by like natural differences between like men and women.
Innate, right?
Exactly.
Okay. Yeah, I mean, so the courts are not going to strike down a regime where, say, if you want to join the military as a Marine, you have to run a 5-minute mile, and for a female, a 7-minute mile, right? I'm making up numbers. But the courts aren't going to strike those down because they may recognize certain anatomical differences in the aggregate between men and women, such that different standards could apply. That wouldn't fly, though, with a racial classification. Imagine if black cadets had to run a 5-minute mile and white cadets had to run a 6-minute mile. That wouldn't fly. But for gender, they seem to uphold it. So another hand somewhere. I agree. What's wrong? Okay. All right, anything else on this general frame? I really spent an hour on this, but you'll have a much deeper understanding than just jumping to the cases. Because the cases are fairly easy. They're not many moving parts here. It's pretty obvious what they're doing. Dustin, my first row friend. Okay. Don't worry, I'll never again forget. Let's see the facts of Frontiero, please.
Frontiero?
Yes, sir.
Miss Frontiero was a lieutenant in the Air Force.
Good.
And her husband was a veteran who was in college full time.
Good.
And they were denied when she applied for BAH. And
tell us what, are you a vet?
Yeah.
Okay, tell us what these things are. Oh, perfect. You're the right guy to call in this case.
basic allowance for housing, which is an additional stipend for housing.
So if you're married in the military, you get extra money, basically, right?
Yes.
Okay. So explain how did this system work for the Frontieros?
You have to apply and provide proof that you have a dependent or additional dependents.
Uh-huh.
And in this case, she didn't provide sufficient
Does
proof.
everyone have to provide the same level of proof?
No.
Okay, good.
Male soldiers do not. Well, they do now, but they did not at this time.
Okay. So for male soldiers, if you said you had a wife, was there any documentation you had to submit?
At that time, no.
At that time, no. But if you were a female service member, like, what did you have to submit? Just a second.
Not only did she have to submit proof that they were married, but she also had to submit proof that he was more than 50% dependent.
Very good. Dara, I'll get you in a second. Yeah.
Did they have the same standard and they just not enforce it, or were there separate?
I think there were actually separate regs. And if I had to guess, maybe Dustin, you know more about this than I do. The long standard was always, as long as you had a dependent, you got the allowance. And then when women were admitted to the service, they added an additional reg about husbands. This, I think Camry's question about half an hour ago, but I suspect this was added later because of a general distrust that the husbands actually need the money. And they're saying, we're not going to be engaging in fraud and handing the money away to all these husbands who don't really need it. Right? I mean, you can imagine how this came about, but I don't know the history. Okay. So you have this regime. If you were a female service member, you had to give all this proof. If you were a male service member, you didn't. So the actual plaintiff wasn't Sharon Frontiero. It was her husband, Joseph. Right? And this is the Ginsburg strategy. They focus on the guy who's getting screwed over. Look at this guy, right? He was, having to do this extra work and getting fewer benefits. Right? So, Frank, the first question for the court was one of scrutiny. And they referenced this other case, Reed v. Reed, that was decided, I think, a year or two earlier. What was that case about? Referenced.
Scrutiny?
Do you know? Jared, what was Reed?
I forget, we talked about it earlier.
I did talk about it. Do you have Alex?
It's a
I'll come
case-
back to you, Frank. Don't worry, you're not done.
It's a case of the court references that held a statutory preference for male applicants was unconstitutional.
What do you mean a statutory preference? What was going on there?
There was an Idaho statute that was under contention, and they talk about like romantic paternalism that influenced that statute as well as the
Good. So what was going on there? Idaho had a law that said if the court needs to appoint an administrator of an estate, right? Someone dies without a will, and the court has to appoint an administrator. The presumption is, if all things being equal, the male should get preference over the female, right? That was the only reason why. There was no rationale, had nothing to do with who was smarter, who was better equipped to be the administrator. It was simply the case that a male would have presumption over a female. The court struck that down. And if you read Justice Brennan's discussion of that, you think the court was applying strict scrutiny. I went back and checked. Reed v. Reed said they're applying rational basis review. So this is peak Brennan. He was so good at this, at characterizing old opinions dishonestly to change precedent. He was a master at it. It's a work of art, really. So Reed was a case that applied rational basis that struck down this Idaho statute, right? And then he traces his history, this long, unfortunate history of sex discrimination, romantic paternalism that Alex mentioned a moment ago, so that women should be put on a pedestal, but indeed it was more like a cage, he wrote. He quotes at length from Justice Bradley's opinion in the Bradwell case, and he says that these statutes are laden with, quote, gross, stereotyped distinctions between the sexes. And indeed, he says that the position of women in the 19th century was comparable to the position of blacks under the pre-Civil War slave codes. And we talked about that before, if you agree or not. Though women's positions have improved, they still face pervasive and at times subtle discrimination. All right? That was his wind-up, so to speak. That was his building up. So Frank, why does Justice Brennan, or sorry, let me ask the question like this. What sort of scrutiny does Justice Brennan seek to apply in Frontiero?
They want to apply strict scrutiny.
Okay, so Brennan wants to apply strict scrutiny, but an important limitation, Frank. How many justices joined his opinion? It's mentioned in the note before the case. Flip through your book. Yeah, flip through your book. Give your book. Jared.
4.
4. What do we call an opinion with 4 justices? What's that called? Plurality, exactly right. When you have an opinion, I can't spell. Oh, God, plurality. Oh man, I can't spell plurality. Wait, plurality. Like you know what I'm talking about. I'm an awful speller. It's one of my weaknesses. Plurality. When a opinion has only 4 votes, it's not law. Right? The fact is 5 justices found this law is unconstitutional, but the 5 didn't agree on a rationale. Therefore, Justice Brennan's holding that strict scrutiny applies is not controlling. Right? But indeed, he found strict scrutiny applies. So Jared, walk me through, why does he think that strict scrutiny is appropriate for gender-based classifications?
I think he was trying to go through the rationale of, like you talked about earlier, like what would the compelling interest in like ways to achieve it. And he was just talking about that administrative efficiency or ease.
Oh no. Forgetting this case, why in general does Brennan think that strict scrutiny applies for gender-based classifications? What's his thinking there? You're jumping to my next question for Carissa, but you're there in a minute.
Okay. Well, they did use the Fifth Amendment, but I'm guessing it's just sort of like the immutable differences. Basically, like there's no difference in the standard for men versus women. Like,
yeah.
As far as like he's making the argument, well, what's the difference or hardship having that same provision for women as it would be for men?
Exactly right. The court applies the the court says that gender, right, is immutable in the same sense that race is. He calls it a phrase that's often quoted. An immutable characteristic determined solely by the accident of birth. An immutable characteristic determined solely by the accident of birth. And Brennan says that people should not be held responsible, right? They should not bear a burden for stuff they had nothing to do with. They were literally born this way. Man, female, black, white, whatever it is, they were born this way. And it should be treated the same way. He adds that sex frequently bears no relation to ability to perform or contribute to society. And if you notice, he puts the word frequently in there. Not never, but frequently. I think even there he's conceding that there may be some classifications. And you have to imagine what's in Brennan's mind, right? If he says you apply straight up strict scrutiny to gender, that means in 1971, 72, bathrooms are now unconstitutional. Locker rooms that are sex segregated are now unconstitutional. So he doesn't quite go that far. But you can tell that's lingering in his mind. He also references the fact that Congress has taken a number of statutes to prohibit sex-based classifications. For example, Title VII, the Equal Pay Act, the Equal Rights Amendment, which passed Congress but was never ratified. It's an odd thought for Brennan to say that Congress can define what the 14th Amendment means, right? That statutes Congress passes give meaning to a 130-year-old provision. But Brennan was never one for text or history. That wasn't his thing. Okay. So at the very end, the court says strict scrutiny applies, and whatever sort of administrative convenience the government asserts is not adequate. Right? But again, only 4 votes for this case. There are only 4 votes. So the law is struck down, or the regulation is struck down, but there's no single rationale why it's struck down. Yes, ma'am.
But even if this was held under intermediate scrutiny, would it still be held unconstitutional, or like would it be held constitutional under intermediate scrutiny?
So you're asking a very good question, but the phrase intermediate scrutiny didn't exist yet.
Right. But like
So,
if they
okay, I'll get your question in a second, I promise. So one of the reasons why I don't like teaching ConLaw by topic is because you forget that there's actually time elapsing. And these three cases, Reed, Frontiero, and Craig v. Boren, were decided within the span of a couple years of each other, 5 or 6 years. And there were rampant debates about, what about strict scrutiny, what about this, what about that? And until you got to Craig v. Boren, this notion of mid-level scrutiny didn't really exist. It was something people were talking about. Now, let me answer Alex's question directly. Were the exact same facts presented 20 years later, right? The exact same facts presented 20 years later, this would absolutely fail intermediate scrutiny, right? Absolutely. Brennan was hoping to get a 5th vote for strict scrutiny. Never quite got there. Never quite got there. Jamie.
Just a while ago you said, I was trying to look up because you said he pretty much said Congress can interpret the 14th Amendment.
Well, what Brennan said was that the judgments of Congress that they prohibit sex discrimination should influence how we interpret the 14th Amendment. And actually, you read my mind. It's actually not even the 5th Amendment. It's the equal protection component of the 5th Amendment. Remember this doctrine of reverse incorporation from Boren v. Sharp? Right. The 5th Amendment, which applies to Congress, has no equal protection clause. But in Boren v. Sharp, the court reverse incorporated. So it's even less original. So it's all over the place. Carissa?
I don't know what the exact language of the statute says, but could they have changed it instead? I mean, so it could be facially neutral instead, like say, like this kind of goes with like your example of like firefighters. So could they have said instead of service man or service woman, could they just said that people in the service with spouses? Because then like it would be just like facially neutral.
That's fine.
Like applying to
Right, but then would everyone have the same burden, both men and women, husband and wife?
right.
That's fine. Yeah. There's nothing wrong. Well, let me ask you this question, Carissa. Can the military give additional benefits to married people? What if you're just living in sin, right? You have a boyfriend or girlfriend, shacking up on the they even let boyfriend and girlfriends live in military quarters, or is it you have to be married?
They're on separate floors and separate sections.
Wait a minute. So married couples are on one floor, unmarried couples are on another floor, or
married housing is a separate portion of the base. Typically.
But they do have unmarried housing.
Yes.
I bet they didn't back then.
No, definitely. And there's
So, Chris, let me ask you your own question back right at you. Can the government classify based on marital status and give additional benefits to people who've actually got married and deny benefits to people living in sin? Unmarried housing, I'm sorry. I mean, dramatic on purpose, which I often am.
I would say no.
Why not?
Well,
Does the government have a good reason to reward married couples and not reward unmarried couples?
under what reason?
Why would government want to reward marriage? I'm leading towards that.
Suppose that it's cheaper? I don't know.
What do you think, gents?
I would say if you're leaning towards marriage,
And can the government endorse marriage by giving benefits to it, and not endorse marriage by denying the sinful hippies?
could you say that it's like a more like the government? I guess the government hopes that like a married couple are gonna like have kids, future the nation, or like keep.
Okay.
We're going down.
You see where I'm going with this, right? You see where we're going with this, right? So your question, Chris, is right on target. Can the government classify people based on marital status, such as giving tax benefits to married couples all the time? And what people who couldn't get married? 2 men, 2 women, brother and sister. All right. Stay tuned. Stay tuned. We'll get there. I promise. We'll build up to it. Don't worry. Every class builds on the next. But Chris, your question was well put. So the holding then, right, of a Frontiero versus Richardson is no holding. 4 votes say that classifications based on gender are given strict scrutiny. That does not get 5 votes. Therefore, there's no law there. No law. No law to apply. But then we get to a couple years later, and Craig v. Boren. And again, these cases are not decided in a vacuum, right? There's development going on. Between these cases, there's lower court litigation. There's people writing, thinking, speaking. And there's definitely a feedback loop where the justices react to what's going on. And Brennan's footnote, was a footnote 14, I think, directly responds to that. So, to Jen's, I did you already, yeah?
Well, I mean, I went short.
Okay, well, I appreciate that. She appreciates it. So, be your next. Jens, give me the facts then in Craig v. Boren, please.
So, an Oklahoma statute didn't let boys that were the age of 18 by non-intoxicating 3.2% beer.
Do you know what that is? 3.2% beer?
That's like my
I think it's actually even worse. And what are 3.2% beers?
When I lived in Utah, they only sold 3.2% beer at the store because it's not intoxicating.
Yeah, you got this is Josh. Yeah, near beer. That's what it's called. Exactly right. Anyone ever have it? Yeah. Gross. Disgusting. Okay. So basically, it's such a low. One at a time, please. It's such a low content alcohol that it basically won't even make you drunk. Right? Yeah, it's not very good. So describe from the law at issue in Oklahoma.
It says that it prohibits the sale of non-intoxicating beer to males under the age of 21 and females under the age of 18.
Okay. So again, here we have a case where the women are not being discriminated against. Women can buy the beer at 18. They're good. And in fact, the plaintiff in this case, this is Curtis Craig. I'm sorry. Let me go through them. So this is actually a picture taken. It's a little bit blurry. But this is a picture taken in 1996 on the 20th anniversary of Craig v. Boren. And this is Fred Gilbert. He was the criminal defense lawyer. This is Carolyn Whitener. She owned the Honk and Holler grocery store. Right, that was actually one of the plaintiffs because the grocery store owner, the Honk and Holler, wanted to sell beer to 18-year-old boys and wasn't allowed to. So she was claiming an injury because she couldn't sell beer to an entire class of people. That's Justice Ginsburg. And that's Curtis Craig, who at the time was a college student, but he was the plaintiff. So again, the plaintiff was not a woman. The plaintiff was a dude, right? And the owner of the shop. So we have these cases. We have Reed v. Reed, which applied rational basis, got a majority of the court. We have Frontiero, which we discussed a moment ago, that applied it applied strict scrutiny, but only had 4 votes. And that brings us to Craig v. Boren. And Justice Ginsburg argued this case as well. And Justice Brennan got, I think, 7 votes. Okay? What did he get 7 votes for, Kern?
They said that the law was unconstitutional because it violated equal protection.
Okay, walk me through, right? Why does this law, this Oklahoma law regarding beer, violate equal protection?
So the state offered proof that there were more males arrested for DUIs than females.
Okay.
But the court said that it wasn't enough proof, that they needed a more objective classification. That it wasn't enough proof to show the difference between male and females.
So I think you have the answer already, but what sort of scrutiny did the lower court apply to this report? You can guess, try to figure out. What tier of scrutiny did this report apply?
Oh, strict.
Strict? What was prevailing law before this case was decided? What was Reed decided under? I said a moment ago.
They said that they could allow gender.
What do we call that? What's that level called? Josh? Rational basis, right? Reed v. Reed was a rational basis case, right? And I'll put it up here just so we have it. Rational basis, right? This is the most lenient of all the categories. And it asks the classification based on everything else. What do I mean everything else? Everything that doesn't fall into strict or intermediate drops to rational basis. It's basically everything. So classification based on basically everything else must be rationally related to serve a legitimate government interest, right? Let's just dwell on this for a moment. Cameron, your hand up?
Okay. I don't know if I can hear, but in paragraph 2, it says the state constitution shall agree with that classification by whom a certain employee must essentially rise to the team of the day. What basis are they?
Brennan is being Brennan. The answer to your question is in the very last sentence of the case, or in the very last page of the case. I think the last paragraph even. We'll get there in a few minutes. But what Brennan's doing here is he's basically changing the law. and he's so good at it, you can't even quite tell what he's doing, right? He's moving smoothly, doesn't say this, doesn't say that, and the last paragraph hits. So I'll get there in 3 minutes, right?
Is this like the same, like, kind of like with the Commerce Clause, like?
Exactly.
Like infants up there?
Exactly. So under the rational basis test, right, if you're classifying based on virtually everything, it must be rationally related to serve a legitimate governmental interest. So let's start with, Terry, I'll go back to you. What's the difference between a compelling governmental interest versus a legitimate governmental interest? What's the difference in those two words? Compelling versus legitimate.
I think compelling sounds more like it's persuasive. And
Persuasive, yeah, okay, good.
And legitimate just sounds more like it's irrational. It's something that probably has a good basis.
Do you have to agree with it to be legitimate?
No.
Do you have to agree with it to be compelling?
Usually.
Right. So here's the one big difference, right? For something to be compelling, I like the way she phrased it. It has to be persuasive. It has to be something that, you know what, this is something that, you know, I think is important. For it to be legitimate, however, I don't have to agree with it, but is this like insane, right? Is this like something a legitimate, a valid government could actually do? So the scope of things that you can do with the rational basis review are much broader. Okay. And let's focus on the next part, this rational related. Andrew, compare for me, please, narrowly tailored with rationally related. What's the difference?
So it would just be a difference in scope. Narrowly tailored is essentially the court has held that it's got to be as narrowly tailored as it could possibly be, whereas rationally related could be it gives the state a little bit more leeway to determine what exactly.
Yeah, leeway. Good. I like the way you phrase it too. It gives more leeway. With strict scrutiny, the government has one option and one option only. If they want to use a racial classification, they must use the most restrictive means available to them. However, with rational basis, they have a lot of leeway. They can pick and choose 1 of 2 ways or 3 ways or do 4 things, whatever they want to do. And their goal to achieve doesn't even need to be that important. It could just be legitimate. Oh, Sam stepped out. I'll go back to him later. Sam, you're on. You should have wash your hands a little longer. So your question, Sam, is applying rational basis review. You were next. I just told Andrew 30 seconds ago. Applying rational basis review to the Craig v. Boren case, right? What's the state's interest in reducing the sale of alcohol age for men and women? What are they trying to achieve there?
Less accidents.
Yeah, vehicular accidents, maybe alcohol poisoning. I mean, you can imagine different things. Are those interests legitimate of the state to do?
I would say so.
Why do you say so?
Well, you know, the state is interested in protecting the people of their state.
Yeah, police power, right? The state, I think everyone would agree, has a legitimate interest in keeping our roads safe, right? You don't want, because when you have a DUI, other people get hurt. It's not only the drunk person. Whoever they slam into gets hurt also. All right, Sam, one more question and you're off. Is the government's decision to sell light beer to 18-year-old girls, but not to 21-year-old boys, is that rationally related to serve that governmental interest?
Well,
and your friend Andrew a moment ago said rationally related suggests that there's leeway, right? Is there leeway in deciding that we can decide this age for girls, this age for boys?
What do you mean?
If you're in a bathroom, that's a problem, right? Lauren, is there a rational relationship here? Why?
Because since it does have more leeway, like even though it may not be like the narrowest way to like reach the end of protecting the people of the state, it could logically be one way to.
Yeah, logically, okay, yeah. Could a legislature, as Lauren said, logically conclude that to keep our roads safe, we need to have one age for beer for boys and one age for beer for girls? Logically, yeah, I think the answer is yes there. And Lauren, you think you'd agree with that logically? To that? So the district court in this case, and Craig, upheld the regulation based on this sort of rational basis review. right? They said, look, it's not perfect, right? Maybe the state has some statistics showing that girls are more mature than boys. I don't know. Maybe these numbers are good. Maybe they're fake, right? We don't know. But it's good enough under rational basis review. So it goes to appeal. Savannah, according to Justice Brennan, what's the real reason why Oklahoma, not statistics, what's the real reason why Oklahoma has this law in the books?
I think he thought that it was just kind of based on stereotypes.
Yeah, give me more. I think we alluded to this before, but give me more.
Well, he thought that men were less mature than women, and they were more likely to cause an accident or encourage drunk driving and things like that. And so he didn't really think it was based on this compelling interest. It was more just stereotypes.
Yeah, he describes this one scene where if a girl gets a DUI, the cop takes her back home. If a boy gets a DUI, he gets locked up. Right? I mean, that's what Brennan's saying. That is what motivated this law and not any concern about safety. Under rational basis review, all the government has to say is, we think this has helped keep our roads safe. We have some statistics. That'd be enough. Right? But Dyer, what does Brennan do? And this is perhaps the most peak Brennan opinion you'll ever read. This is Brennan at his finest. What does he do here? By the way, Brennan, I keep mentioning Brennan. Who's William Brennan? William Brennan was an appointee of Dwight Eisenhower, a Republican. But he went to be probably the most liberal justice ever. Maybe Marshall a little bit to the left, but as far as influence, he was probably the most liberal ever. And Brennan would often tell his law clerks, what's the most important number at the Supreme Court? 5. Because with 5 votes, you can do anything. And he firmly believed that. He would often cobble together majorities that you can never even think of that reach some result with convoluted reasoning. But if you get to 5, he was happy because that means lower courts have to follow it. So he was very adamant about achieving liberal goals without any concern for text or history, so long as he got his 5 votes. And here he got 5 and then some. So Dyer, what does Brennan think about applying rational basis review in this case?
It's unfairly discriminating against males. But they ought to, that the low statistics that they're using to correlate things aren't enough to justify it.
So why does Brennan think these statistics are not enough? Well, I mean, the government's actually giving some numbers here. I mean, if any of you ever bought an insurance policy, if you were an 18-year-old boy and an 18-year-old girl, I can tell you the girl will have a lower premium than the boy. I mean, insurance does this all the time. Why is this so irrational, according to Brennan? Kent, want to take a stab?
I remember calling it an unduly tenuous fit for the amount of numbers that they're so lovely, ridiculous. The difference between the male drunk driving and the female drunk driving, 2% and 0.25%.
Okay.
Of the overall population. So we're not talking about the population as well. We're only talking about a small percent population.
Good. Kent, you had your hand up?
I think you mentioned the correlation was so weak that it didn't justify.
Yeah, I think you both just said the same thing. So well done, you two, on the same wavelength. He's basically saying, as a matter of statistics, the difference is so small that this does not permit a distinction on this basis. Basically, your numbers aren't good enough, right? You gave us numbers, they're not good enough. They're not good enough, they're not good enough. And then I want you to look at footnote 14. This is why Brennan, if you have the page, just shout out, I know the page. You know footnote 14 in the case? Oh, that has to change. Oh my God. It kills me because I read the original cases and never remember what's in yours. Okay, so footnote 14. Unsatisfactory, so it's excluded. I'm making a note right now. Footnote 14, Craig v. Boren. Okay, thank you, Dustin, for shaking your head. In footnote 14, he says, there's this new middle tier. He doesn't use the word intermediate. He says there's this middle tier review. While I would not endorse that characterization, candor compels the recognition that the relatively deferential rational basis review takes on a sharper focus for gender cases. He's basically saying we've never adopted rational basis review, but we'll be doing it now. I'm sorry, we've never adopted intermediate review. We're doing it now. So in a footnote, he announces intermediate scrutiny. That's it. Brennan. Middle tier review. So we have now in our classifications, we have the strict scrutiny, we have rational basis, and we have what's known as intermediate scrutiny, right? Where does Brennan define the test for intermediate scrutiny? Does anyone know where it is? I think I told Cameron a minute ago. Brent, you know where it is? He defines it, but it's in a very strange place. Oh God, please let this better be in your book. If it's not up. Yeah, what's the very last sentence? Actually, what? Does it say a sentence that ends, in fact, when it's further recognized? Oh, you go, Vault. I'm sorry. This is one of the growing pains of switching books. I forget what's in and what's not. Okay, so I'll read it to you. Actually, I'll show it to you. It's on your book. I'm sorry. Craig v. Boren. It's in the dissent. Yes, you're right, but it's not in the majority for inappropriate reasons. Okay, so let me give it to you. Okay, so it's in like this very last section, right? If you can't read this, I'll read it loud for you, but it's important. So don't Google in class unless you're up here, right? In fact, when it's further recognized, it is. Yeah, okay, I'm gonna read it, whatever. It's here. It's here, I'm gonna read it. Enough time. In fact, when it's further recognized that Oklahoma's statute prohibits only the selling of 3.2% beer to young males and not their drinking the beverage once acquired, right? In other words, this only respects who can purchase it, not who can drink it, okay? So here comes the test, right? This we have to copy into your notes. The test is this. The relationship between gender and traffic safety becomes far too tenuous to satisfy Reed's requirement that, here's a big one, difference be substantially related to achievement of the statutory objective. The gender-based difference, or you can say the gender-based classification, be substantially related to the achievement of the statutory objective. Okay? That's Brennan defining the test in the very last sentence of the damn thing. So here's your test. Is the gender classification substantially related to the achievement of the statutory objective? And he doesn't say it there, but in a later case they add the word important here. So I'll cut to the chase a little bit. Is the gender classification substantially related to the achievement of the important statutory objective? And to make it consistent, I'll say government objective because it doesn't have to be a statute. You see what he did there? He carved into the middle of the court's framework this new level. So, Brent, I'll start with you. What's the difference between compelling governmental interest, important governmental interest, and legitimate governmental interest? Walk me through that, right? You got compelling up here, you have important down there, you have legitimate over there. What's the difference?
Very subjective, very thin. Compelling, you would assume that the government would provide dramatic, specific, on-point evidence that safety as a whole would be affected of the nature. Intermediate.
What does it mean to be important?
You have to impress the justices, I guess.
And what does it mean to be legitimate?
Not arbitrary.
Not arbitrary. Okay. So you see what's going on here, right? Brent's right. They're subjective, and you have to concede that. But there's a hierarchy here. From low to high. For something to be legitimate, it basically has to be non-arbitrary. It has to be like not insane. For it to be important, there's got to be some policy there why you want it or not. But to be compelling, man, to be compelling to the highest state order. So what Brennan's doing here is saying, look, there may be important reasons why women should be treated differently, but they need not be compelling. For example, modesty and privacy in a bathroom. That could be an important interest. Is it compelling? Possibly, possibly not, depends who you ask. Is it legitimate? Certainly. So you have this hierarchy from legitimate to important to compelling that the court builds upon in the Craig v. Boren case. Okay. And Patrick, what's the difference between, if I may, I'll underline them so they're clear, or italicize, rationally related, substantially related, and narrowly tailored? Walk me through, what are the differences between those three concepts?
Rationally related would be close enough to furthering the government interest that it like reasonably furthers it, whereas one above it, substantially related, is it against objective, but it's a little bit more. That interest is powerful enough that it furthers it. Not.
You're on track, Charles. Give it a go. How would you characterize these different types of relationships?
So, starting with the most strict, narrowly tailored, you're only hitting your objective and nothing else. That
There's no overflow, right? You're getting exactly that, but nothing else.
Right.
Good.
And so, down one, you're mostly hitting your target, but there's a little overspray.
A little spray, maybe, right?
And then the bottom, rational basis, if you hit your target, it don't matter what else you hit, more or less.
So, I mean, if you could use it, right? Laser pointer, buckshot, fire hose. I like your metaphor, right? Maybe use that next year. Right. So if you use basically a laser point, you're zapping it right in the point. Think of like a surgeon, right? You're performing surgery. If your incision is like a centimeter off, the patient dies. Right? If this is why I can never be a surgeon, I have no dexterity. But if you're a surgeon, you're doing brain surgery, and your thing's like a centimeter off, the guy's dead. It's an awful thing, but it's true. So strict scrutiny is like you're performing surgery, and you gotta be damn precise. With intermediate, maybe you're not performing surgery, maybe you're a pipe fitter, right? And you have to make the pipes pretty good, or else it'll leak. Okay. And if you're a rational basis, you're a fireman, right? And you're spraying the building. Wherever it goes, and you hope you get to the fire, and if you destroy a roof here and there, okay, you try, right? And maybe that's one way for you to all think about it. But the combination of the means and the end, right? The means, that is how narrowly tailored you are, and the ends, that is what you're attempting to achieve. This is a critical aspect of scrutiny. So you can do much more than just memorize these statements. Anyone with a horn book can memorize these, but I want you to actually understand how these concepts interact and how Brennan burrowed into the middle, this intermediary, this middle tier standard. Okay. So questions in the majority, and Craig? Yes.
Actually, I have kind of a question about this.
Okay, we'll get to consent in a minute. Yeah.
Or no, I'm sorry. It was a concurrence, actually.
Okay, or if I ask what the concurrence. Whatever.
So I noticed Justice Powell, he agreed here, but then in the previous case, he said that he said in the previous case, he said the plurality.
It's a hard word, isn't it? Yeah.
Incorrectly adopts governmental classification as strict scrutiny, but here he seems to.
Well, he's okay. Powell's okay with intermediate, but he's basically saying Reed was not as broad as Brennan made it seem. I think this was actually Camry's question a few minutes ago. Brennan was trying to make it seem like these other cases were really tough, and they weren't. Right? Reed was a rational basis case. He's basically trying to lie about it. And Powell is saying that's not what Reed meant. Powell, for background, was a Nixon appointee. He was a Virginian and a conservative, but in a traditional sense. He was very much a moderate. He was the Justice Kennedy of his day. He wrote the opinion in Bakke, you may recall, the middle opinion about diversity. So he had that kind of Kennedy-esque flashback. Okay. Anyone else on the majority? Okay. Let's move on to the concurring. You already said Powell. Justice Stevens had a fairly important concurring opinion where he says there's only one equal protection clause. This 2-tier, 3-tier, 7-tier, whatever it is arbitrary, right? We should judge all classifications equally. That never got more than one vote. That was Justice Stevens' position. He maintained it for 33 or 34 years, but that was always his position. Justice Rehnquist wrote a dissent, and Rehnquist's dissent is, well, first of all, like 2 years ago, you said that gender gets strict scrutiny. Are you already abandoning that for Brennan? Yeah, why not? You get 5 votes, doesn't matter what you do, right? You get the right result. Rehnquist would apply a rational basis scrutiny. He said that statistics are more than enough, that the state doesn't need statistics to actually hit its mark. They can fire hose away. Because sex is what's known as a suspect class. You'll see these phrases elsewhere. Suspect and non-suspect, okay? And of course, the quasi-suspect we'll get to in a minute. What's a suspect class? It's a class for which strict scrutiny applies. That is race, religion, nationality, right? What's quasi-suspect? This is basically when intermediate scrutiny applies, and it's gender, and as well as thing we don't think about much, but legitimacy, right? Can the state deprive bastards, that is, people without married parents, of various property rights? You probably never think that's such a case, but these were cases in the 70s. And I'll get a second, Jamie. And for non-suspect, that's the rational basis review, everything else. So if something's a suspect class, it gets strict scrutiny. Is quasi-suspect, that would be the gender, intermediate, and everything else gets rational basis. Jamie?
I was reading that you posted about immutable characteristics, and then I saw suspect class. Was that created to be for religion in it?
So here's the difficult part, though. Is religion immutable?
No.
Of course not. People can convert. People don't have to practice, which is why this doctrine is somewhat garbled, right? Religion is not immutable in the same way race is. You can change your religion. Perhaps there are other reasons why strict scrutiny applies to religious classifications, but immutability is not one of them.
Okay, so it's just one reason.
Which is why I don't make a big fuss about immutability. And if you want to bring even more current, the notion of gender identity means it's not immutable, that you can change your gender. And that puts the entire suspect classification on its head. So immutability is not a favorite phrase nowadays. All right, anything else on Rehnquist's dissent in the Craig v. Boren case?
I had a question.
Okay, then I'll come to you, Nathan, after that. Jamie, go for it.
Oh, I was wondering why he used case law. Williamson was in 1995. Did the case that we just read prior to this not overturn that?
Williamson v. Lee Optical?
No. Yeah, I was wondering why he referenced that.
We'll cover Williamson v. Lee Optical. That case has not been overturned. That case stands for the proposition that when you have a non-suspect classification, rational basis scrutiny affords. Right? What this court said is gender is no longer a non-suspect class, it's quasi-suspect class. Therefore, rational basis does not apply. So it's not that the 1950 era case was overturned. The court said here that gender moves up the ladder, so to speak, to quasi-suspect review. Okay, Nathan, then Camry?
So on an exam, should we not write immutable?
You're welcome to write it. But if you look at the court's recent cases, we'll do Lawrence v. Texas or Bergefell, that phrase does not appear. It's not a commonly used term with respect to it. Camry? I didn't say that. The court doesn't quite, this is why Jamie's question is a good one. It doesn't quite explain why is gender not suspect, other than the fact that Brennan could get 5 votes. Yeah, I think that's the best answer. Not a good answer, but I think that's your answer. Alex. Good. Anything else on Craig v. Boren? All right, let's do the last case, or not the second to last case. We'll do Cleburne. Will be actually fairly quick because it's a case whose validity is not too important. So the last case, or the second to last case, involves the Virginia Military Institute. You ever heard of it before you went? What do you know about VMI?
VMI was up until this case.
Yeah.
Just after this case, an all-male college.
Did you go to academy or?
No.
Okay. So where are we? All right, AJ, give us the facts, please, in the VMI case. By the way, Justice Thomas recused. Why? His son went there. Ah. Okay, go ahead, AJ.
The Virginia Military Institute was a male-only military college, basically where they trained people to become citizen soldiers.
Yeah, what the heck is that? It sounds pretty ambitious.
But basically, they wanted to train them for leadership in the civilian life and military service.
Okay. Yeah, what's this method? How do they describe it?
It was adverse.
Yeah, this is not like Socratic method, my friends. Did anyone ever go to military academy? Anyone ever? I would have flunked that after like 5 minutes. I would not have made it very far. But yeah, they have this adversarial. I'm sorry, adversative. Sorry, the adversative method to instill physical and mental discipline. And as a result, for over 150 years, this state institution was sex segregated, that only men were allowed to attend. This case came to the court in the 1960s. And by that time, there were a number of cases involving gender discrimination. There was Frontiero, there was Reed, there was the Craig v. Boren case, right? So Alex, what was the state's interest for why they asserted a need to separate men and women in this educational program?
Because the process that they designed was to put people to like their limits, and it was super stressful, and to allow women into that same environment would radically change the methodology of how they deal with their structure of the entire thing.
Good. Yeah, exactly right. The school argued that allowing women to admit to this program would change the dynamics. They'd have to change the living quarters. They'd have to change the physical fitness requirements. They'd have to worry about, romantic relationships, right? There are the distractions or a host of other rationales. Okay. Now, Josh, can you think of a good reason, an actual good policy reason why in the Air Force they had one policy for male service members and another policy for female service members benefits? Is there actually a decent reason for that? What about the alcohol and the no, right? I think most people would agree. What about here? Do you think the state has maybe a stronger reason why they can have sex segregated facilities than compared to the Air Force case or the beer case? What do you mean pure monetary perspective? Oh, I see. So they don't have to build a second set of dormitories and bathrooms and stuff. Is that your rationale? Isaac, what do you think? Does the state have zip back up across the top, right? How would you rank the state's interest here compared to the Air Force case or the beer case?
Well, their interest is maintaining this particular harsh and adversarial, male-oriented, because of the people that it produces for the purpose of producing good military officers, producing people who have high levels of leadership, because the military was traditionally a male undertaking. It was thought that they would use that maleness that had people like that.
So
to do it in quite spectacular, something primal would want.
Something you say primal? Yeah. Okay. Cameron, let me ask you a question, right? So we have this intermediate scrutiny test, right? And they say the government's objective, right? An important government objective. Is the government objective of having this male-only education program important? At least, according to Justice Ginsburg, at least. Why not? What evidence does she adduce to support the idea that this is not such an important governmental interest that you need all-male military academy? What are some of the evidence that she brings forward? Michelle? How do we know that having this all-male thing is not that important according to Ginsburg's majority opinion? What are some of the evidence points we have?
Well, she do. Let's say, like, she would say, this is a long and unfortunate discrimination. So she was saying that these classifications were once used.
All right. Steve, I think you have it.
Yeah, I think so. So she's saying that that it never existed for diversity because it excluded.
Okay.
So you can't really buy that argument.
Well, but
She uses evidence that women have already successfully entered into the federal military.
yes, yeah.
And
She says, look, the West Point, the Air Force Academy, Annapolis, right? These are the most elite military institutions in the United States. They've all admitted women, and they found a way of making it working, right? So how important of an objective could this possibly be if these other schools have done the exact same thing, right? The exact same thing by having co-ed programs. Sergio?
And like those schools are the gold standard, and Ginsburg also said like, yeah, even though the VMI is a military academy, only like 15% end up going to the military.
So it's actually not as exclusive as they think it is. Is that what you're saying? They think they're all hot stuff and they're not.
Yeah, like this school like West Point, Annapolis, and Colorado Springs, that's the main point to make up offices.
So they're not as nearly as cool as they think they are, right? Cameron, let me come back to you, right? So Ginsburg's saying that this is not an important governmental interest. Let's talk about narrow tailoring. Does the government have to do it exactly the same way that West Point and Annapolis? Why can't there be leeway, so to speak? Virginia does it one way, West Point does another. Why does Ginsburg say that this is not proper tailoring?
Okay, I'm sorry, I don't have my notes.
Okay,
I
that's
promise
fine.
I do English.
That's fine. Samantha?
Okay, repeat the question.
Why does Ginsburg think the tailoring here is not proper, right? Okay, so what? West Point and Annapolis, they have co-ed programs. Why can't Virginia do it differently? Or why does Virginia have to do it the same ways as other schools? Why can't they have the leeway to do that? Chandra?
Is it because like only 15% of the graduates actually go into the military?
Why does that matter for intermediate scrutiny?
I think that history raises that point in order to say that they're not really meeting their goal to raise like these great people.
So you're saying they're not even achieving the goal they're trying to set out to achieve, right? Well, but Keyshawn, what if you know it's a mediocre school, right? Why can't they do things differently than West Point and Air Force Academy? Why does Virginia not have that latitude there under this intermediate scrutiny standard?
Is that to do like with
No, funding. Why can't Virginia do it differently than these other schools? Why don't they have that discretion? Bradley? I think I guess. Cameron? No, they're all public schools.
Because with West Point and the other schools, the remedy that they use to provide the equal opportunity for women, but then here that what they try to do didn't do
Well, what did, okay, this was getting at, what were they trying to do?
So they created the separate school.
Ah, the separate schools. It was Mary Baldwin, right?
Yeah.
Give me more.
Well, but it was way worse.
It was way worse. Okay, what's going on there?
I mean, they said the SAT scores were lower, fewer PhDs, less. It was it just, I mean, so it said it didn't
Yeah.
fix the past discrimination or for the future.
Okay, so we're running a little bit low on time, so I'll summarize. What the court basically said here was the objective of trying to have this citizen soldier, right, can be achieved without gender segregation. West Point did it, Air Force Academy did it, and look, your effort to have a separate school with this lower ranked program is not closely related enough to achieve that goal. It's not, I mean, to use the phrase here, substantially related to achieve that goal. You're doing something else. You're giving the girls a second-class education. Now, Justice Scalia's dissent says, wait a minute, right? This is not intermediate scrutiny. Remember, laser pointer, pipe fitter, fire hose. Justice Ginsburg is not quite giving fire hose scrutiny. She's not giving pipe fitter scrutiny. This is laser, right? You have to do it the exact same way that West Point did it. So perhaps one of the biggest criticisms of the VMI decision is that the court here wasn't really applying this middle tier review. That what it was applying was looked an awful lot like strict scrutiny. We're saying the evidence the government gave is not accurate. That's not enough. That's not enough. That's not enough. Do it like West Point did it, right? This is not the least restrictive means. It's possible to do it this way or that way. Who's to say maybe having a second college, given enough funding, could be better? The court says it's not allowed. So as a result, the court strikes on the VMI program, but Scalia and Scalia alone, again, Thomas was recused. His son was a student there. His son's actually a state trooper in Virginia now, for whatever it's worth. That was unconstitutional. Okay. Questions on the majority opinion or the dissent? Alex?
I just don't understand Scalia's two of his arguments. One, he says like, well, you know, the history and tradition of it, blah blah blah. Then you could say, well, then why did we ever overturn slavery? There was like such a strong history of slavery in the United States. And two, he says that those other schools changed it by decree of the people, but isn't this the people coming to the court saying we want this changed? Like,
Was there a vote on this? Did the people of Virginia vote on this?
no, but it's still somewhat, it's still women in Virginia coming to the court and saying we want this changed.
But is that a democratic process?
I mean, arguably, yes. Why do we have the courts?
Are the courts democratic? Or are the courts counter-majoritarian?
I mean,
Indeed, if the people of Virginia wanted this, they would have done it already. The reason why these women went to the court was because Virginia did not vote to change this. Right? The courts in this case are basically saying, we're doing what the Virginia electorate would not do. We're going to strike this down. If Virginia wanted to, they could desegregate, remove the gender segregation tomorrow. Nothing would stop them from doing that. Right? The courts are not democratic. If any of you are watching the hearings, you know, the number of the questions for Judge Gorsuch are, how do you see, the popularity of the court, and should the court be doing this or that? He's like, look, I'm a judge. I'll apply the law before me. True or false, but the court is certainly not a democratic institution. 5 people can override the votes of hundreds of millions overnight. Yeah.
When Ginsburg was talking about how you should just give them the availability to be able to apply, like don't keep their willingness to want to go to the school.
Hmm?
Why is it so necessary for us to change to change so much? Couldn't they have just left things the way they were and women would realize maybe it was too hard or maybe it was really small?
Well, indeed, and this all summed the class, but female cadets made it through the program. So they made it through. I don't know how many actually made it through, but here's a picture from the first graduating class, their graduation. They made it through the program.
So the school's still here?
Still exists, yeah.
Talked about
Hasn't fallen apart yet.
Scalia was talking about how it destroys it and just erases.
Well, Scalia had a flair for the dramatic, as he always does. By the way, I actually did an interview on this recently. The reason why Scalia wrote such dramatic prose was for you. Me? You. He wrote this for law school textbooks. He said this many times, that when you put something very punchy in a dissent, it makes into a textbook. And that way generations of law students read it, indeed, after he's gone. There were other dissents in other cases that you'll never read, but Scalia's dissents were, oof. They made you, ugh, right? You hate him, but you know exactly what he was saying. And that's why he wrote them. So that was for you, Jamie. You're welcome.
Wow, that was cool. Because you asked him the first thing, like, what is it about this? And the word was unique. He's talking about how now you're taking that are unique away and making them non-existent. Which would lead me to believe this whole.
All right, we're almost out of time. Bring questions up afterwards. I want to talk about the final case. I can summarize this one pretty quickly. Cleburne versus Cleburne Living Center from Cleburne, Texas. Anyone from Cleburne?
Yeah. My family's from Houston.
It's somewhere between Waco and Dallas, I think, right? So the facts of the case were like this. You had a group home for mentally retarded people. This is not a phrase people like using today, but it's a phrase that's used in the case, so I'll use it. Under the laws in this city, if you wanted to open up an apartment building or a fraternity or a boarding house, you could open one up, no problem. But if you wanted to open up a home for mentally retarded people, then you needed to get a special permit, which, shocker, was not granted. The big question in this case was, how do you classify people with mental handicaps? Do you give them some sort of suspect classification? Do you give them quasi-suspect classification? Or do you give them a rational basis review and say they're non-suspect? The majority opinion by Justice White holds that mentally handicapped people are subject to a rational basis review. They are not suspect classifications. However, and this was the big however, what the court does in applying this case is not rational basis review. They're basically dismissing the government's evidence. They're saying, no, fire hose is not good enough. You gotta be more precise. Maybe like a sprinkler, right? You gotta be a little bit more direct. Garden hose, maybe, instead of a fire hose. And some of the rationales given are not adequate. So as Justice Marshall notes in his dissent, this is an instance where they applied what might be called rational basis with BITE, B-I-T-E, this sort of heightened rational basis review. And this was this sort of, if I could put it graphically, right? Somewhere between here and here, right? Somewhere between the intermediate scrutiny and rational basis review. These sort of things drove law students nuts. It's like, oh God, now we have a fourth tier to worry about? Okay, so, and I will finish the class on this concluding note. None of this matters. None of this will matter because of Anthony Kennedy, who does not like scrutiny. What you're going to see in a number of cases we'll read over the next few weeks. By the way, there's a picture of Justice Ginsburg and Scalia and an elephant. They went to India together and they wrote an elephant. It's one of the coolest pictures ever. They're very good friends. But if I can conclude, one of the things you'll find about Justice Kennedy is he doesn't care about scrutiny. In Rumor v. Evans, in Lawrence v. Texas, in United States versus Windsor, in Obergefell v. Hodges, all the LGBT cases, he does not care a word about scrutiny, not a word. It's irrelevant to him. So all of your hand-wringing about figuring out these damn tiers will go out the window next week when you discuss Justice Kennedy's opinions in the gay and lesbian marriage cases. He just doesn't talk about it, doesn't care. For him, dignity is what matters. Tiers of scrutiny do not. So as you read Justice Kennedy's various opinions in these cases, don't forget about scrutiny, but pay very close attention to how he deviates from it. And in particular, as Justice Scalia notes in his dissent, the court's failure to apply any meaningful doctrine. All right, I think that's all I have time for today. Any questions, please come up, and I'll see you all on Thursday.